Hello everybody, welcome to EPG Pathshala. I'm Monica Sakrani and we are looking at the second module of family law, where we will be looking at the law of divorce and looking at the debates on Uniform Civil Code. This is the course Legal Literacy. We have just looked at law of marriage and now we look at what is divorce. So divorce basically brings to an end all legal relationship between the parties. If I'm married to somebody, I can inherit from the person. I am a legal heir of that person. But once I get divorced, then I cease to be the legal heir and I have no rights over each other. So certain rights still continue, which we will look at in the next module. So we have already looked at all the laws which relate to marriage. More or less it's the same laws which relate to divorce also, except for Christians, where there is a separate law for divorce, which is the Divorce Act of 2001. So now we look at the different laws of divorce under the different laws for the different religious communities in India. Now, as I've already said, the marriage laws or the matrimonial laws in this country for different communities are more or less similar, and as they are all based on the English law, matrimonial law of the time. But the Muslim law for divorce is still largely customary law, and it's governed by Sharia. So we look at the Muslim law before we look at all the other laws. Now, the Muslim law of divorce gives both the man the right to divorce, the woman the right to divorce, and also provides for mutual consent divorce. When a man divorces his wife, it is known as talaq. Recently, we've been hearing a lot about talaq and the Sharia in the Shaira Banu case and the triple talaq, which has been challenged in the Supreme Court. The Supreme Court is hearing the case. Now, that kind of talaq is known as talaq-e-biddat, which is the triple talaq, where the man gives a divorce to the wife 3 times in a row. The divorce becomes final, and then the woman goes through her iddat period, and after that she can get married if she wants to. So this is known as the triple talaq. It can be oral or in writing. So there can be a talaqnama, or it could be in orally, but it has to be given before a witness, and the talaq has to be communicated to the woman. There have been various judgments of the Supreme Court as well as one of the Bombay High Court, which said that talaq has to be communicated to the woman in order for it to be a valid talaq. There is a Bombay High Court judgment which says that talaq has to be preceded by attempts to reconcile. Family members have to be involved, because if it is under Sharia, then the Sharia, what the Sharia dictates has to be followed in order for a talaq to be valid. The 2 other types of divorce or talaqs are talaq-e-hasun and talaq-e-hasan. These are the Sharia itself disapproves of the talaq-e-biddat and says that this should not be followed, and talaq-e-hasun or talaq-e-hasan should be followed. Now, this would be either a man utters the talaq once during what is known as the tuhar. Tuhar is the period when a woman is not menstruating. So he gives one talaq to the woman during the tuhar, and follows it with a period of abstinence for the entire iddat period. And if after that he does not, during this period, if he consummates the marriage, he cohabits with the wife, then the talaq automatically comes to an end. If he does not cohabit with the wife or does not have sexual intercourse with the wife till the end of the iddat period, then after the iddat period, the talaq also becomes final, the marriage gets dissolved and the woman's iddat period also comes to an end. So, or he can do it over 3 separate tuhars. So every time she is not menstruating, he gives her 1 talaq, then she gets her periods, and then he gives her a 2nd talaq, and then the 3rd talaq, and at the end of it all, the talaq becomes final. So these are the forms. This also gives the man and the woman the right to reconcile, because if talaq is given at a time when he's in there's a fight and he's angry and emotionally distraught, and at that time on the spur of the moment he gives her a talaq, He can always, there is a probability that the marriage may still be saved. Once they cool down, they can talk, and there is a possibility of reconciliation. So these are the two types of talaqs that are approved forms of talaq under Sharia. When a woman gives a divorce to the husband, there are two forms of divorces apart from the Resolution of Muslim Marriages Act. Now, in the previous module, we said that prenuptial contracts are permitted under Islam. Now, prior to marriage, the woman can get the right to divorce. The man can give his right to divorce to the wife, and after the marriage, she has the right to give a talaq. It's called the deferred talaq. She can give the talaq to the delegated talaq. She can give the delegated talaq to the husband. So she has the right to divorce the husband whenever she wants to, and all her rights on divorce are held intact. The other way in which she can divorce her husband is through a khula. In this, she gives the husband something in consideration of the divorce. So she gives him a divorce, and she gives up some of her rights on divorce. So for example, she gives up her right to meher in a khula. Apart from that, the third type of divorce is the mutual consent divorce, where both the husband and the wife decide to go in for a divorce, and this is known as a mubara. So talaq, this will be generally in writing, and it will be before the qazi. Now, apart from this law, all the other laws, as we have already stated, there are almost identical grounds of divorce. So we'll be looking at all the divorce laws, and we'll be looking at under the grounds for divorce, and we'll be looking at under which laws, which personal laws give you the right to divorce for these grounds. So there are what we call the grounds for divorce. So divorce cannot be unilateral. In Islamic law, I don't need to give any reason in order to give a divorce. I just don't want to live with you, therefore I'm giving you a divorce. I want to get married to somebody else, therefore I'm giving you a divorce. So there is no need for, because it's a contract, either party can get out of the marriage. But when marriage is seen as a sacrament, there has to be a bigger, greater reason for you to get out of that marriage. So we, borrowing from Victorian law of England, have come up with this fault grounds of divorce, which is that I am asking for a divorce because I have been wronged, and I am the innocent party, and the other person is at fault, and therefore I want a divorce. So so we have what is known as fault grounds of divorce. We look at what constitute fault grounds of divorce within the next few slides. But if I am filed for divorce, I am a petitioner. The husband or the wife, the respondent, can also file for divorce on similar grounds. So if suppose cruelty is a ground for divorce. So I am saying that my husband has been cruel to me, and therefore I want a divorce. My husband can come to court and say that I have been cruel to him, so therefore he should get a divorce. So a counterclaim can also be filed. So, whoever is alleging a fact has to prove it. Another form of divorce which has come about recently is mutual consent divorce. From 1976, the marriage laws were amended in keeping with the changes that Western societies have made. In the West today, fault grounds of divorce are done away with, and you have what is known as mutual consent divorce or irretrievable breakdown of marriage. So mutual consent divorce is when both the parties are agreeable to a divorce and they don't want to make any allegations. Both the parties say that, we don't want to live with each other anymore for whatever reason, and they say that, we don't want to go to court and wash our dirty linen in public. We are agreeable to certain terms and conditions of the divorce, and we are filing a mutual consent divorce. That can be filed. So it's a no fault ground for divorce. The other is that if I filed a mutual consent divorce, there are certain conditions that have to be fulfilled. Now, the first condition in almost all divorce cases is that the divorce case cannot be filed within 1 year of marriage, because the courts don't want people to take marriage lightly. So even though the law provides for divorce, the law itself doesn't want couples to get married on a whim and get out of a marriage on a whim. So generally you can't present a petition for divorce within a year of marriage unless you get the permission of the court to do so. In mutual consent divorce, you should have lived apart for 1 year before you file the case for mutual consent. So you have to show that you've lived apart. This need not be that your addresses are apart. It means that there's been no cohabitation between the parties. In marriage, marriage is a sexual or a conjugal contract. So not having sexual relations shows lack of cohabitation. So you have to show that there has been, so even if people, because of reasons of convenience or lack of other alternatives, are living within the same roof, it does not mean that they are cohabiting. So you have to show that they are not cohabiting. Once you file the case, both the parties have to go to court and sign the petition and present a petition. You can have separate lawyers, but you can have the same lawyer also. And either party, because it's mutual consent, either party has the right to take back its consent. The court gives 6 months time to the parties. So even if it's a consent petition, the court keeps it pending for 6 months in order for the parties to reconsider the decision. And after 6 months, if both of them go back and say that we don't want to live with each other, we want a divorce, then the court grants you a divorce. If for 18 months the parties don't go back to the court and ask for divorce, then the petition automatically lapses and a fresh petition will have to be filed. But if within this period one of the parties withdraws the consent, then the consent divorce cannot be granted. As I was saying, that now in the West there is this new concept of divorce which is known as irretrievable breakdown of marriage, which has come about. Irretrievable breakdown of marriage is very much like the unilateral divorce amongst Muslims, where one person says, I do not want to live with this person and therefore I want a divorce, because marriage is now increasingly being treated as a contract. So in India we still don't have a law which permits irretrievable breakdown of marriage. The Law Commission in a report has recommended that irretrievable breakdown of marriage be made a condition for divorce or a ground for divorce. But the Supreme Court in several judgments has granted divorce on grounds that the marriage has irretrievably broken down and the parties cannot live with each other anymore, and therefore there's no point in keeping the marriage going. But the Supreme Court has said that only they can grant this divorce under Article 142 of the Constitution of India. So for irretrievable breakdown of marriage, these are cases where parties have litigated for 20 years in the court, where one person has filed for divorce and the other person has, and has not succeeded in proving that they have a fault ground, and they have not been granted divorce on that ground. Then the court has, on grounds of compassion and convenience and on the fact that the marriage is actually not only existing in paper, granted divorce to the parties. Now, amongst the Hindu law also permits customary forms of divorces, where a community follows customary forms of divorces like chod chitti, etc. The community can continue with the form of divorce. Now, what are the forms of divorce? Grounds for divorce, fault grounds of divorce. Now, the foremost fault ground of divorce is cruelty. Cruelty can be both mental and physical, and it should not be normal wear and tear of marriage. So, cruelty can be both physical and mental. Then there is adultery. So this is covered under all matrimonial laws. Cruelty is a ground of divorce. Adultery is a ground of divorce under all matrimonial laws. Adultery basically means where a person is in a sexual relationship with somebody apart from the husband or the wife. You have to name the other person in your petition. You have to make that person a party to your petition and name that person as what is known as a co-respondent. That because the person has to have the right, if I am named in somebody's petition and I am not called in court at all, then I do not know that I am actually there. So I should be heard. I should have the right to, clear my reputation. Because it can be, one of the things that was written in the previous slide is there should be no collusion between the parties. So if a husband and wife collude, like for example, under the Indian Divorce Act, the grounds of divorce were very limited. It was, husband could get a divorce on grounds of adultery, whereas a wife could get a divorce on grounds of adultery coupled with cruelty or coupled with desertion. Now in that case, and there was no mutual consent divorce, so many of the couples would actually go to court and file a adultery case in order to get a divorce, because they couldn't get a mutual consent divorce. So in this case, if somebody else is being named, I have a right to be named, to be a party before the court and to prove that there's no collusion. Or if the wife is suspecting that I'm having an affair with her husband and she says that so and so is having an affair with my husband, I have a right to go and clear my reputation. So in that case, yes, adultery can be a ground for divorce, but the person has to be made a party and it has to be against a specific person. Suppose I'm alleging that my husband has been having affairs with several women, then I can file for divorce on grounds of cruelty, saying that it is mental cruelty to me. The other ground for divorce is desertion. Desertion is leaving a person's company and going away. This is also a ground for divorce under all the laws. But desertion, you cannot file immediately. For most laws, you have to wait for 2 years before you file for desertion. For Muslim law, you have to wait for 3 years before you file a divorce on grounds of desertion. In many cases, I can file for multiple grounds. I can say that there was desertion, there was cruelty, and there was adultery. Or I can say that there was cruelty and there was desertion. So I can file for more than one ground for divorce, but I'll have to prove each of the grounds. Apart from that, there are other grounds for divorce where the husband has not, whereabouts of the person has not been known about for 7 years. Under law, if a person is missing for 7 years and their whereabouts have not been known, then the law presumes that the person is dead. If the person, nobody who would otherwise have heard about the person has not heard about the person has disappeared, then the law presumes that the person is dead, and the legal heirs can then inherit from the person the property that belonged to that person. But the wife's marriage, or the husband's marriage, does not come to an automatic end if the person is not known about for 7 years. You still have to apply for divorce and get a divorce, otherwise your marriage will still continue. So if you remarry, then your second marriage will be a void marriage, because your first marriage has not been dissolved by the court. For Christians, another aspect that is important is that the church grants annulments, and the grounds for annulment are very similar to the grounds of divorce under the Indian Divorce Act. The Indian Divorce Act was amended in 2001, bringing into sync with all the other laws. So now all these grounds for divorce also are there. All grounds of divorce are available even to Christian couples or people married under the Indian Christian Marriage Act. And the Indian Divorce Act was amended in 2001 because of that, expanding the scope of divorce. The other thing that it did was bring in the aspect of mutual consent divorce. The other form of divorce is that you can get a divorce on grounds of mental disorder. In this case also, if I know that a person is suffering from some kind of mental disorder and I marry that person, the ground of divorce will not be available to me. I should not have known, there should have been a suppression, it should be continuous, and it should affect the marriage for me to get a divorce on grounds of mental disorder. There are other grounds of divorce available under different laws, which one can see in the slide, which includes undergoing sentence of imprisonment for 7 years or more if a husband has been convicted for rape or sodomy or bestiality. If for Hindus, for example, if the husband has or the wife has relinquished the world and gone away, has renounced the world and has taken sannyas, then that becomes a ground for divorce. Apart from that, other grounds for divorce include any kind of sexually transmitted disease or leprosy, provided that it is contagious, then you can get a divorce on those grounds. So there are several grounds for divorce under different laws, and for the Muslim women, they have additional grounds of divorce where they can actually get a divorce on grounds that the husband is actually remarried and is not treating her equally as he's treating the other wife, or he's not paid her maintenance. Also, for Hindus and Muslims, what is really important is that if a girl gets married below the age of 15, she has the right to opt out of the marriage up to the age of 18. So she can actually, apart from the Child Marriage Act, which makes the marriage voidable and she has the right to get out of marriage, under the Hindu law, she has the right to get out of the marriage up to the age of 18. Now, of course, because of the Child Marriage Act, she can get out of the marriage up to the age of 20. But under this law, she can get out of the marriage up to the age of 18. Now we look at, so these are, apart from these, if there is any violation of any condition of any order of the court, the person gets a right to get out of the marriage. So if the husband has been ordered to pay maintenance, and for 1 year he has not paid maintenance, and there is no resumption after the order of maintenance, if for 1 year there is no resumption of cohabitation, then under certain laws the person can apply for divorce. The other thing is that there is a concept called judicial separation, which we have not looked at. Judicial separation is when you go to the court on similar grounds as these, for fault grounds, and you get an order not of divorce but of judicial separation. Now, because divorce earlier had a lot of stigma attached to it, many people did not want to live with the spouse but did not want a divorce, did not want a formal break of marriage. So you continue to be legal heirs of each other, but you get an order of judicial separation. So if your judicial separation has been passed 1 year back, then you can file, either party can go and file for divorce saying that there is no resumption of cohabitation. Similarly, if there is an order of restitution of conjugal rights, and either party, if there is no cohabitation, resumption of cohabitation for 1 year, then it can be filed for Hindus, Parsis and Special Marriage Act, and for Christians it can be only filed after 2 years against the party refusing to cohabit. For Christians and Parsis, a willful refusal to consummate marriage is a ground for divorce, and if the wife was pregnant by a man other than, so for Parsis, for others it is makes it a voidable marriage, but for Parsis this makes it a ground for divorce. Now we look at what is cruelty. As already stated, it is mental and physical cruelty. The courts have held that it does not mean normal wear and tear of marriage, but something beyond that. Till recently, the courts were not willing to say what exactly constituted cruelty, and they generally said that it depended on the context of the case, on the facts of the case. But in a recent case, Samar Ghosh versus Jaya Ghosh, the court laid down certain acts which would amount to mental cruelty. Mental cruelty allowed certain things like, for example, refusal to have sexual intercourse, not taking care of the other, refusal to live with the person, refusal to if a person falls sick, not taking care of that person. So there are certain aspects which will amount to mental cruelty. Generally, one single act is not seen as cruelty. It would require more than one act, though there have been judgments in which a single act also has been held to be cruelty. But cruelty involves two aspects. One is what is the nature of cruel treatment, and the other is what is the impact that it has had. Even in physical cruelty, one single act, of course, a very gross act would amount to cruelty. But there has to be a reasonable apprehension that it would be harmful or injurious to live with the person. That is what is required. So there is something called condonation in all marriage laws. Condonation means that I have condoned, the person has done something wrong to me, but I have condoned or I have forgiven that person. So it means forgiveness. Now, generally in a matrimonial relationship, condonation is done through resumption of cohabitation. If I have resumed conjugal relations or marital relations with my spouse after they have done something wrong, then I can't go to court and ask for divorce on grounds or for the act that I have already condoned. Now, desertion also is important ground for divorce, it requires two important conditions. One is that there should be the fact of separation, and the other is that there should be the intention to bring the cohabitation permanently to an end. So if a wife is thrown out of the husband, then she is not consented to the divorce. She has no intention to bring the cohabitation to the end, but the husband has the intention to bring the cohabitation to an end. So he has deserted her, not she who has deserted him. Similarly, where the deserted spouse is concerned, it has to be without her consent and the absence of conduct which gives reasonable cause for the spouse to leave the matrimonial home to form the necessary intention as aforesaid. So if the husband is having an affair with another woman, therefore the wife leaves the husband and goes away, then the husband cannot say that she has deserted me, because he has given her reasonable cause to leave the matrimonial home to form the necessary intention. So in this, we have now looked at the law of divorce. Now we look at some of the issues relating to Uniform Civil Code. Now Article 44 of our Constitution directs the state to bring in a Uniform Civil Code, which will bring in a uniform marriage law in India, marriage and divorce and other inheritance, etc. Those aspects of laws will be uniform for all communities. Now this has been much debated in this country. Now the debates are against the right to freedom of religion, which is a fundamental right, versus the Uniform Civil Code, which is a directive principle. On one hand, the debate is premised on that. On the other hand, it is premised as women's rights or gender parity as against right to religion, which are both fundamental rights. Now the first time the issue came up was in the Bombay High Court in Narsu Appam Ali's case, where the state of Bombay in 1952 brought in a law which prevented bigamous marriages amongst Hindu men. So the matter was challenged by saying that it discriminated between Hindu men and Muslim men who had the right to marry more than once. And it also talked about the right to religious freedom and the fact that Hindu religion gives the man the right to marry more than once. Now the court held in this case, they refused to strike down the law by saying personal laws are not laws passed by the parliament, they are religious laws, and therefore they cannot be challenged using the constitutional principles. In another case, Ahmedabad Women's Action case in 1997, AWAG, which is a women's group in Ahmedabad, actually looked at all the personal laws which are passed by the parliament and said that these discriminate between men and women, and these are so on grounds of gender discrimination they should be all struck down. In this case, the Supreme Court said that this is a matter of policy, and it is for the state to decide the parliament to decide what kind of laws to pass, and they refuse to interfere. In another case, Shah Banu's case, which we'll be looking at in the next module, the court actually recommended that Uniform Civil Code should be brought in. So today we have various debates on Uniform Civil Code. Different people have different positions. So there are these four frameworks. One is that there should be a Uniform Civil Code for all. The other position, the other polarized position is that no, personal law should continue. And the two mid positions are that there should be a Uniform Civil Code for all and option to choose personal laws for those who want to use to be governed by personal laws. And the others is what you call reverse optionality, that is personal laws for all and an optional civil code for those who wish to opt for the same. So in India today, actually the position that we have is the last position, because we do have a Special Marriage Act under which those who want to opt for civil laws or a secular law have the right to opt for it. Any two people, irrespective of which religion they belong to, without conversion can get married under this act. Even if I belong to the same religion as my husband, I still have the right to opt for to marry under the Special Marriage Act. So this is an option. This is the present position that we have today in India. So thank you very much. We have looked at personal laws, the debates on Uniform Civil Code, as well as the law relating to divorce in this module.